Okay, so I had recorded a video earlier for you guys. It was on Obama and the jobs plan, but I thought because of all the recent buzz around the Troy Davis case, we could kind of touch on it, especially since the media is talking about it, so you can get insights from what the information I give you as well as the media. So I'm going to give you a little insight. Troy Davis was convicted on August 19th of 1989 for the murder of a police officer named Mark McPhail in Savannah, Georgia. At the trial in August of 1991, the district attorney sought the death penalty. According to the prosecution, Davis had shot Michael Cooper, then met up with a friend, Red Coles, at a pool hall, then pistol whipped a homeless man named Larry Young, and then killed Mark McPhail. Trial witnesses claimed that Davis had struck Young and then shot McPhail. Coles admitted arguing with Young, but stated that Davis had not hit him with a pistol whip, but Cole instead. During Davis's 1991 trial, witnesses testified that they had seen Davis shoot McPhail, the police officer, and two others testified that Davis had confessed to them. A murder weapon was never required, and ballistic evidence presented at trial linked bullets recovered at or near the scene to those of another shooting, in which Davis was also charged with. Davis was convicted of murder and various lesser charges, including an earlier shooting, and was sentenced to death in August of 1991. But since 1992, 7 of the 9 eyewitnesses signed affidavits changing or recanting all or part of their testimony. There were 34 witnesses testified for the prosecution at the trial. The limited ability to appeal his conviction is due in part to the Anti-Terrorism and Effective Death Penalty Act. One provision of this act limits the power of federal judges to grant relief unless the state court's negotiation of the claim results in a decision that was either 1. Contrary to or involved an unreasonable application of clearly established federal laws as determined by the Supreme Court, or based on unreasonable determination of the facts in light of the evidence presented in the state court proceeding. The first execution date was June 25th of 2007. Davis' first criteria petition, which is a petition seeking judicial review to the U.S. Supreme Court, was denied, and his execution was then set for July 17th of 2007. Davis' case gained a lot of public exposure and awareness from a lot of individuals. They gave support, and that included Nobel Peace Prize winner Archbishop Desmond Tutu, who urged the courts to agree to hear of the evidence and recanted testimonies. An appeal to the governor of Georgia, Sonny Perdue, and the Pope at the time urged them to spare Davis's life. So on July 16th, the day before he was supposed to be executed, the Georgia State Board of Pardons and Paroles granted a 90-day stay of execution so evidence could be looked over once again. His defense lawyers requested for a new trial because of the evidence and the recantment of statements on March 17th of 2008. They were denied by 4-3 majority. Because of this, his lawyers then petitioned for right of criteria by the U.S. Supreme Court, arguing the Eighth Amendment. An execution date was then set for September 23rd of 2008. It was now up to his attorneys to get the Supreme Court involved so that he wouldn't be executed. And even former president and Georgia's governor at the time, Jimmy Carter, got involved by writing a statement claiming that if Georgia had gone through with this execution of a possibly innocent man, it would be a grave miscarriage of justice. A last-minute stay of execution, literally hours before he was set to die, halted the execution. This continued on for years as Troy's lawyers continued to get support and ears of the Supreme Court, moving his execution date 4 times. On August 17th, 2009, the Supreme Court ordered that the courts do a rehearing of all the new and old evidence that could be obtained for the innocence of Troy Davis. During his August 2010 appeal, he again asked for a new trial. The petition this time was rejected without comment by the Supreme Court in March of 2011, allowing a new execution date to be set. It was set on September 7th to be September 21st of 2011. The evening of September 21st, he was supposed to be executed at 7 o'clock, but got a temporary stay, which was said to be a delayment for a couple of days, but being he ended up being executed by lethal injection that night. It was claimed that he did not get this temporary delay stay because he had essentially too many temporary stays. So it was time for him to, I guess, in a way, move on. They decided that they've kind of had enough of the trial and that this was the set execution and that he was to be executed. And so on September 21st at 11:08, he was pronounced dead from lethal injection that started around 10:53. So my questions are as followed. Do we feel that, we have enough information to convict a man of murder even though the only evidence was eyewitnesses? Do you feel that we need forensics evidence as well to convict someone as strongly as for the death penalty? There are also a lot of Americans that claim this is simply a racist act in America. Do you agree? Especially with the case of Casey Anthony that just ended. Many feel that there was so much evidence clearly pointing to Casey Anthony saying that she killed her daughter and nothing officially pointing to Mr. Davis. Some are even complaining that the president should have stepped in and should have gotten involved, but essentially because this is a state case, he could not get a lot of say or have a lot of push into it. Mainly because of checks and balances. So do we believe or do you think that because this had to do with the life and death of another American, that the president should have more of a say and should have more of a push towards this? And then also, I also want to know about how you guys feel about the death penalty in general. Do you feel that it should be banned from America or do you feel that it's a probable cause? So just a little food for thought.